Miranda rights come into play when two things happen. A suspect is in custody, arrested, or not free to leave, and police want to question the suspect. Luigi's attorney is clearly showing that he was not free to leave. Really no physical exit for him to leave. Seems like he was in custody, and they didn't read him his Miranda rights, so you tell me.
Hey, it's Jordan. I am in Flint, Michigan, East Palestine, Ohio, Tumwa, Iowa. Please support the only independent outlet on the ground covering what the corporate media covers up.
Hey, it's Jordan with Status Coup. A major and I believe potentially explosive court filing was filed at the end of last week by Luigi Mangione's attorney in Pennsylvania. And that court filing, from my reading, it's 23 pages, and I just read the whole thing. It only became available yesterday. Could have major ramifications for his case in Pennsylvania, as well as his state of New York case and federal case. And when I say ramifications, I mean actually help him. Disclaimer, I'm not a lawyer, but I read a lot on Google while reading this 23-page document. And it sure seems, based on my reading of it, his arrest in Pennsylvania and several parts of it might have been illegal, and therefore evidence that was obtained against him from that arrest might be suppressed, meaning not admitted into trials against him. Before I get into the reading of the court filing, and I'm going to read most of it, so buckle up, don't go anywhere. Let me show you what his New York attorney, Karen Friedman Agnifilo, said specifically about this search and seizure violation in Pennsylvania. This is what she said about it outside of the courthouse where I was on Friday.
And we are concerned that Luigi's constitutional rights were violated in Pennsylvania, and there are serious search and seizure issues that will be litigated in that case in Pennsylvania and in this case here and in the federal case, because it is alleged that Luigi had a gun on him and had other property on him that they are going to use against him in all of the cases. And if there is a search and seizure issue, and again, we have to review all of the paperwork and camera footage when we receive it before we say definitively whether we think there is one. But so far what we are seeing is we think there is a serious search and seizure issue. And so we want the opportunity to litigate it, including in Pennsylvania, where he was supposed to have a court date on February 24th, but the Department of Justice is refusing to transport him and allow him to face the charges in Pennsylvania. So he cannot litigate those issues in Pennsylvania.
So she is referring to his Pennsylvania attorney's filing, which I believe was filed that day on Friday. I want to show you something else she says, because she indicates that this potential search and seizure violation, which I'm going to go into in detail, could suppress evidence not only in the Pennsylvania case, but also the New York case, the state of New York against him and the federal government's case against him. Let me show you that part.
And so we are concerned, because if the chief of detectives is telling everybody about all this evidence, and what if it ultimately gets suppressed because it was an illegal search and seizure in Altoona, Pennsylvania, how is he going to get a fair trial?
Okay, now that I have set you up on their concerns and their allegations of the illegal search and seizure in Pennsylvania, I am going to go through the document. Again, it's 23 pages. I'm not going to read the whole thing, but I'm going to read extensively. So I know we only have so much time, you and the audience, but if you're interested in this case, I really hope you'll stick with me because honestly, the allegations by Mangione's Pennsylvania attorney are explosive and seem to me that the Pennsylvania cops seriously fucked up, which might fuck up all cases against him. Or at least give Mangione's defense a much better chance than they would have had. All right, so I'm going to start with this part. This is in the motion. The defendant believes that the instant charges are not supported by a prima facie case, so that's the petitioner's detention or confinement on the instant charges are illegal. Legal terms, prima facie case means that the claims being presented to a court has merit. when taken at face value. So they believe basically they do not have merit. Petitioner further avers, which is basically asserts, that any evidence seized, obtained, or in the possession of law enforcement and or the Commonwealth purportedly in support of any of the instant charges was obtained illegally and unlawfully. So let me take you through the sequence of events here. On December 9th at the McDonald's in Altoona, where he was detained. On or about December 9th at approximately 9:29 a.m., defendant was approached in a McDonald's located address in Altoona by two uniformed, armed, and fully equipped officers of the Altoona Police Department. Said uniforms exhibited badges, patches, and other identifying insignia indicating their identity as police officers. And real quick, I will put the link to this motion in the description if you'd like to read along. Defendant was seated at a corner dining table that had a wall directly behind him and to his left. There also was another unoccupied chair to his immediate right. Defendant's only natural path and or route of ingress, egress was to his right, meaning exit would be to his right. Upon their arrival, Altoona Police, Detweiler immediately posted himself to the right of the defendant and within approximate arm's length of the defendant. This action taken in order to detain and or totally curtail the liberty of the defendant and to restrict the defendant's path of travel or ingress, egress from the table where he was sitting. These actions were performed to clearly exhibit said officer's authority over the defendant. The unoccupied chair was between the law enforcement officer and the defendant. No explanation was given to the defendant relative to why the police approached him at McDonald's. At most, police indicated that he had, quote, looked suspicious and had overstayed his welcome as a patron at McDonald's. It is stressed that the defendant was being detained and other than that he merely had overstayed his welcome as a patron at McDonald's. Defendant had been at McDonald's as a customer for approximately 30 minutes. It is clear Altoona Police provides a specious and unreasonable reason for approaching the defendant. To wit, it must be assumed the defendant was being detained for an investigation to which he was not informed. The accompanying Altoona police officer, Fry, positioned himself next to Detweiler's right and next to the dining table, resulting in the formation of a human law enforcement wall, further detaining and totally curtailing defendant's liberty, while additionally restricting defendant's path of travel or ingress, egress from the table at which he was seated. The existence, position, and placement of the two Altoona officers was intentionally done to further exhibit said officer's authority over defendant. So the human wall part is very important. It's kind of like, think of yourself if you've been at a protest and police officers create what they call a shield and then arrest you for not leaving. Well, they've created a shield around you which doesn't allow you to leave. Well, legally, it matters if you are actually in custody, because if you're technically in custody, you're supposed to have your Miranda rights read to you. But technically, being in custody you don't have to formally be arrested. Part of being in custody means you don't feel you have the ability to leave. You don't have the freedom to exit. So that's why the attorney is painstakingly going into the positions of the officers and that they had closed off any ability for him to exit. At no time did the two officers indicate the defendant was free to go, nor did they explain the reasons as to why he was being detained. Upon approaching the defendant, Officer Detweiler immediately made commands and instructions to the defendant, including but not limited to providing his identification, standing up, placing hands on his head, the totality of the circumstances, including but not limited to the positioning, demeanor, mannerisms, commands, directives, instructions, and other actions of Altoona PD showed that at the time the request for identification was made, the compliance with the request was required. Defendant avers that the totality of these circumstances clearly shows that he was seized and unlawfully detained at the time and was in custody of the Altoona Police Department. Any reasonable person in the defendant's position would have thought she was being restrained, detained, and otherwise not free to leave. The curtailment of defendant's liberty and the detaining of the defendant at this time was in violation and in contravention of the Fourth Amendment and the 14th Amendment of the U.S. Constitution and Article 1, Section 8 of the Pennsylvania Constitution. So, Fourth Amendment of the Constitution, that would be, you are protected from unreasonable search and seizures by the government. 14th Amendment has a couple different provisions, but that's the birthright citizenship part, which has obviously kind of been under assault by President Trump. And Article 1, Section 8 of the Pennsylvania Constitution, which is referenced here, security from searches and seizures. The people shall be secure in their persons, houses, papers, and possessions from unreasonable search and seizures, and no warrant to search any place or to seize any person or thing shall issue without describing them as nearly as may be, nor without probable cause. So Mangione's attorney is alleging federal constitutional violations and state of Pennsylvania constitutional violations. And seems pretty clear to me there's meat on the bone here for those constitutional violations. Both police officers from the Altoona Police Department continue to interrogate and question the defendant without any reading of his Miranda rights as required by both the Constitution of the United States as well as the Pennsylvania Constitution. These questions were designed to potentially incriminate the defendant. So I want to get into the Miranda rights. Again, I'm not a lawyer, so feel free to leave in the comments if you disagree with me. Miranda rights, there is a slippery slope and there's different interpretations, particularly by state. But if you really look at the nitty gritty, the main part that's relevant about Miranda rights is when they have to be read, where there is no slippery slope. I'll read this for you. Miranda rights come into play when two things happen. A suspect is in custody, arrested, or not free to leave, and police want to question the suspect. In legal jargon, that is called custodial interrogation. Both parts must be true for Miranda rights to kick in. When is the suspect in custody? While handcuffs are a good indication that someone's in custody, circumstances that fall short of a formal arrest can also count. A person is considered in custody anytime police have deprived that person of their freedom of action in any significant way. In other words, the person doesn't feel free to walk away. Well, here, Luigi's attorney is clearly showing by outlining where the offices were, where the exits were, the manner that they were speaking to him, that he was not free to leave. He wasn't physically, there was no exits physically for him to leave. And the spirit of the questioning and the commands made clear he was not free to leave. Also, what is an interrogation? Interrogation means questioning. Questioning doesn't have to be formal or conducted at a police station. It could occur anywhere on the street, in the squad car, or a hospital. Questions can be direct. Did you rob the bank? Or they could be comments or actions by the officers. Not every situation lends itself to a clear indication that a custodial interrogation is taking place. A judge has the final say on that. Courts consider several factors to determine whether the interrogation was custodial, including how intimidating, coercive, and compelling the environment was. For instance, bringing a suspect to the police station and having an armed officer conduct a 3-hour-long interview points to a custodial interrogation, whereas a 15-minute interaction on the street initiated by the person and not the officer leans towards non-custodial. Well, you got two officers around you. As I'm about to show you, more showed up. There's really no physical exit for him to leave. Seems like he was in custody and they didn't read him his Miranda rights. So you tell me. You tell me. Getting back to this, at no time did the defendant exhibit any threatening gesture or other show of force. Officer Detweiler further directed and commanded the defendant to stand up in order to undergo a Terry frisk, which is a pat down. Although no circumstances existed at that time justifying said action, it is averred that said actions were further performed in order to clearly exhibit the Altoona police officers' dominion and control over the defendant. The Altoona PD took possession and control of identification materials presented by the defendant and continued retention of this material. The positioning of law enforcement officers' personnel and the retention of a person's identification materials for a background check, evidence of criminal activity, and or other investigative measures signal to a reasonable person that they are implicitly commanding the person to remain on scene while doing so. At one point, Officer Detweiler walked outside McDonald's while in possession of identification materials. During that brief interval, Officer Fry remained with the defendant within an arm's length and continued to curtail the liberty of the defendant, block his route path of travel, ingress, egress, and movement from the dining table at McDonald's. Within minutes, other members of Altoona PD, both uniformed and plainclothes, arrived at McDonald's. This resulted in the defendant's path of travel from the dining table being blocked and prevented by two fully uniformed and armed Altoona police officers. Another fully uniformed armed Altoona PD officer remained on the other side of the dining table. Numerous officers, approximately 3 to 4, also blocked the path route of travel from the dining area in which defendant was seated to the service area of McDonald's. A member of the Altoona Police Department questioned the defendant about whether or not the backpack, plastic bag, and other items belonged to the defendant. At that time, Altoona police officers seized the items and packages and placed them in an area behind law enforcement personnel. At all times thereafter, there remained Altoona police officers stationed between the defendant and the items of property believed to belong to the defendant. These items of property remained in the control of Altoona police throughout. Defendant believes this action further supports his belief that he was not free to go. In order for the defendant to exit the dining table to venture to the service area of McDonald's, he would have had to pass no less than approximately 7 to 10 members of Altoona PD. At this time, it is believed that there was an excess of 10 law enforcement personnel surrounding the defendant in the small dining area. It again became abundantly clear that the defendant's curtailment of liberty, seizure, and unlawful detention and custody continued by this group of law enforcement personnel. And once again, the lawyer says this violated Mangione's Fourth Amendment, 14th Amendment, constitutional rights, and his rights under the Pennsylvania Constitution. During this period of custody, various members of Altoona Police continued to interrogate the defendant with the intentions of obtaining incriminating statements from him. The totality of the circumstances presented by Altoona PD again make it clear that the defendant was in custody and that the actions by Altoona PD constituted a custodial interrogation. That word is important, remember, because under the Miranda rights, you have to have your Miranda rights read if you're in a custodial interrogation, meaning you're in custody. Both police officers from Altoona Police Department continued to interrogate and question the defendant without any readings of the Miranda rights. In excess of 15 minutes had passed, and the defendant's unlawful detention, seizure, curtailment of liberty, custody, and interrogation continued. He still had not been given any information as to why he was being held. This continued curtailment of his liberty, seizure, unlawful detention, and custody of the defendant was in violation, again, Fourth Amendment, 14th Amendment, Pennsylvania Constitution. Finally, after approximately 15 minutes of the defendant's unlawful detention, he was advised by Officer Detweiler that he was officially under a police investigation, yet he was still not read his Miranda rights. After approximately 2 more minutes of interrogation, a member of Altoona PD read the defendant his Miranda rights. So this would mean 17 minutes had gone by. And I'm assuming the attorney, reviewed, camera evidence at McDonald's or officer's body camera to get to 17 minutes. At the conclusion of the reading of the Miranda rights, the defendant was asked if he wished to speak to police, which he shook his head no. This statement was materially false. Officer Fox immediately stated to the defendant, "You are not in custody." The statement was materially false, inaccurate, and contrary to the law. It is clear at the time the defendant was, in fact, in custody and had been, in fact, in custody since his illegal and unlawful seizure, detention, curtailment of liberty. Again, unlawful seizure, detention, curtailment of liberty, violation of constitutional and state Pennsylvania rights. After the defendant shook his head no to talk, Altoona PD continued to question and interrogate him and then did another pat down. He was then placed in handcuffs and was informed he was being detained. When you go further, then approximately 7 minutes later, defendant was physically removed from McDonald's, according to police reports, being placed under arrest for the crime of, quote, providing false identification to law enforcement. Said arrest was illegal and unlawful. At the same time, members of Altoona PD commenced a thorough search of defendant's backpack and other items. Defendant avers that this search and seizure was illegal and unlawful and in violation of his constitutional rights and state of Pennsylvania rights. I don't think they had a search warrant for this search. During the search of the backpack, Altoona police uncovered a clip wrapped up in underwear and other items. Contained within the backpack was a separate package secured by duct tape. Said package was opened via removal of the duct tape with a knife by members of Altoona PD without a valid search warrant. There you go. No search warrant to search any of this. Said package contained a computer chip. Defendant avers that this search and seizure was illegal. And then they went back to the Altoona PD and continued to search his backpack, resulting in seizure of several items: 9mm handgun, mechanized upper receiver, suspected 3D printer, 3D printed suppressor, and a red notebook that they're alleging is his manifesto. But at the end of the day, the alleged violations here are plentiful. Illegally basically entering him into custody without reading him his Miranda rights, giving him no ability to exit while you're questioning him, while you're patting him down. Again, you're not issuing his Miranda rights, searching and seizing his property without a search warrant. That, there is, kind of room to operate there, depending on the state, for rules on search warrants and what you can and cannot collect or investigate without a search warrant. But in this case, I think it could be problematic for the prosecution. And the most important thing is the fact that 17 minutes went by where you're not telling him he has the right to leave. But you're doing everything. You're doing everything that if you're an officer, you're doing things that you have to read his Miranda rights and tell him he's being detained, which they did not do. So obviously, I'm not a lawyer, but there's several things about this. Number one, as the attorney in the beginning, as I played in the beginning, said, if evidence was illegally obtained due to an illegal search and seizure, it could be suppressed not only in the Pennsylvania case, but the state of New York case and the federal case. Any evidence that's suppressed would benefit the defendant, Luigi Mangione. Also, even if let's say they get off scot-free with an illegal search and seizure and this evidence was submitted, meaning it's allowed to go forward in all three cases, we've already talked about the concept of jury nullification. So it's hard to find 12 people on a jury that haven't had some type of problem, from minor to, horror stories with the health insurance industry. So there might already be sympathetic jurors that get on that jury. Well, if they also find out, which likely they will, that there's all these allegations that his arrest in Pennsylvania was illegal, that the cops basically were patting him down and illegally searching his backpack, that could influence some jurors. They're humans. So I don't want to give off like a false sense of hope if you are watching and you want Luigi Mangione to be freed, which is not everyone. There's people watching that want him to be found guilty. But seems like small town Altoona cops really screwed up here, whether it was just incompetence or they just didn't care about his legal rights. And Luigi has damn good lawyers. I don't know his attorney in Pennsylvania, but his attorney in New York was number 2 at the Southern District of Manhattan office. That's the creme de la creme. She is well known as a top prosecutor, top lawyer. And with this information, it's very good for Mangione's case. We will stay on this. We will continue to cover his case on the ground like we did on Friday, interviewing his supporters outside the courthouse, as well as healthcare reform activists. We'll put a link to that in the description too. Please support Status Coup for as low as $5 a month. StatusCoup.com/join.